is Nick Giuliano. I'm a lawyer in Philadelphia. I've been doing securities law my entire professional career. What I'm about to tell you is not fair and balanced. I come from the plaintiff side of the business. So for me, my job is generally bringing actions against broker-dealers, trying to enforce the federal securities laws, trying to enforce the self-regulatory rules that most customers hope exist when you have a dealing with a fiduciary, because we like to think the stockbrokers are fiduciaries. Now, as Sam pointed out earlier, when customers open up account at brokerage firms, they agree to arbitration. They agree to binding arbitration before a panel of arbitrators. And there's been a lot of debate lately, particularly in some of the periodicals, a lot of the treatises. What kind of arbitration is it? There's two kinds of arbitrations out there. There's contract arbitration, like the AAA might have, where you sign an agreement and the panel is doing nothing more than acting as a forum for those grievances. Then there's another kind of arbitration. It's called folklore arbitration. And it goes back to medieval times, the law merchant, where you would have a dispute, let's say, between two merchants, and those merchants would have someone from the industry, someone from their trade, decide the dispute. There are no formal pleading requirements or choses in action, because those were all created by the sovereign courts, when the courts created the sovereign. Instead, they would just provide the facts, the relief that they wanted. You'd have an industry person or another merchant decide the legal issues in the case. There were really legal issues. Virtually no discovery. And you would get an award or a judgment that was often unexplained. And if we look at the NASD dispute resolution process, as many commentators think, it's actually folklore arbitration. Because you've got panels who one of the persons on the panel is going to be an industry person, someone who has some tie or some connection to the brokerage industry, former branch managers, registered reps, compliance officers, someone from the industry who's bringing to the table their industry knowledge and expertise, their industry customs, so to speak. As we'll see later, the discovery rules that you folks are used to in a court, well, they just generally don't exist in arbitration. There's no ability to get depositions, for example. The only time you're allowed to get depositions was on the NASD discovery guide, is in case of an ill or dying witness or the unavailability of a witness. Until recently, the parties had the ability to issue subpoenas. Now we have to go, there's a 10-day procedure where you send a subpoena to opposing counsel. If he doesn't object within 10 days, or if he does object, files a motion to quash, you get to respond, and the chairperson of your panel issues an order instead of a subpoena. But that subpoena is relatively ineffective for getting documents or securing the attendance of witness in an like a subpoena ad testificandum, because those people might be outside the jurisdiction of the NASD. If I have a defense case and I want to subpoena documents from a mortgage company, well, the mortgage company is going to look at my subpoena, look at my order, and laugh and say, hey, we're not members of this little club called the NASD. We don't have to comply with your subpoena. And then our only alternative on the defense side or the plaintiff side is to go to court and ask for a judge who does have jurisdiction over the person in a court of competent jurisdiction to actually ask for the documents. So forget about evidence. The rules of evidence don't apply in arbitration. Panels are guided by the rules of evidence, but they're not really strictly enforced as much as we'd like them to be. They're not. So, these are the rights that you're giving up. You're giving up discovery. Since 1987, since the Shearson case you've all read about in your case books, well, there's been no precedent. You read about cases in reporters because someone's trying to vacate an arbitration award. You read about them because for some reason they're not before an arbitration panel for some reason. But there's no precedent in our business. There's no authority. There's no law that's been established, stare decisis, from a way one panel decided a suitability case is not binding on another panel. The awards are issued and they say claim denied or claim awarded, and they give you a number. And we'll talk more about that, but sometimes that number, you have to figure out, where did they get this number from? Well, if we take half the claimant's damage in 6 months, and we apportion responsibility between this one and that one, this is how we get $65,071.35. There's no justification for some of the awards. I'm sure there's justification on the part of the panel who issued it, but it's hard for the practitioners of the parties that are looking at one of these awards to say, where did this come from? Or claim denied because, for whatever reason the panel didn't think you were able to prove your case. there's been a lot of changes in the industry. I mean, I know one of your readings is the Wilco versus Swan case. What has anyone gotten from the court's holding in Wilco? Does anyone, what is the major theme behind, don't forget, this is 1952, 1953 Wilco was rendered? Can someone tell me what the theme behind the court's reasoning in Wilco was? The reasoning was the courts did not trust the arbitrators